All right, thank you. So good morning. It is January 16th. This is Senate Health and Welfare, and we are going to listen to our Ledge Council go through S-192, an act relating to forensic facility admission criteria and protection. And this is related to some of the information that we heard previously. So we have folks from Dale here with us, Karen Barber and Stuart Schur. Thank you both for being on Zoom with us. So, and two of our committee members are testifying in other committees, so they'll be walking in a little bit later. There we are. So Katie, thanks for being here.
You're welcome. Good morning.
Good morning. So why don't we start walking through S-192?
Sure. So Katie McGlynn, Office of Legislative Counsel. Before we look at the language of the bill, I wanted to maybe give you a little refresher of what happened last year and what you're seeing in this bill. So you looked at language very similar to the language in this bill last year. In the end, maybe we should actually even take a further step back and talk about what the forensic facility is. So right now, there's no forensic facility, but the concept is that a forensic facility would be a facility for individuals with a mental health condition or an intellectual disability, which is what the proposal in this bill is. It's an individual who's criminally justice involved, and there is a degree of violence in their history with regard to past charges. So that is sort of the population of individuals who would potentially be at a forensic facility. The language that ended up being adopted last year, Act 27, as you know, it took out all of sort of the mechanisms for actually getting somebody into a forensic facility. Instead, in concept, it said the General Assembly is still interested in moving forward with a forensic facility. Departments, please start moving forward with rules for a forensic facility. There was also that working group that you've already spent some time hearing from, which was the working group with regard to whether individuals with intellectual disability should receive programming and be committed to a forensic facility. So that was all part of Act 27, but the actual mechanism of how DMH, for example, would petition the court to have an application for somebody to go to a forensic facility, all of that was stripped out of Act 27, and that actual mechanism would need to be in place before individuals could actually be placed in a forensic facility. As of last year and within this current bill, the intention is that a forensic facility would repurpose one of the 9-bed unit at the current Vermont Psychiatric Care Hospital. It would no longer be hospital level care, but that is the facility that is contemplated to be used as a forensic facility. Like last year, I'll sort of remind you that the language in the bill talks about a forensic facility and not the forensic facility. The language is specific. That choice is specific because this would allow for additional forensic facilities in the future. So it creates a facility to go to a forensic facility, but not the forensic facility, if that makes sense. And it also creates flexibility that it wouldn't always have to be in that 9-bed unit at the Vermont Psychiatric Care Hospital. It could be in other locations. Okay. So how did we get this language in front of you today? This bill, the sort of template for it was going back to the version of the bill as passed Senate. So sort of the bones of the bill in front of you is the as passed Senate version from last year. There are changes though. So the intent language is indifferent because we're 1 year further along. The rulemaking looks different because we've already asked for rulemaking. We've already asked for some reports and presentations back. So that language isn't in here. One pretty notable difference from the as passed Senate version was a concept that was discussed and presented in more depth in the House. and that's the creation of a human services community safety panel. And that is a panel, and we'll look at the language itself, but it's a panel of individuals within the Agency of Human Services, DOC, DMH, and DALE, and those representatives would be making recommendations as to who should be placed in a forensic facility. And there's some criteria there about how they would make that recommendation. So that's probably the most notable change from the as-passed Senate version to this version. So with that said, I will pull up the language.
So we've got two bills here. We have as introduced, and then we have forensic facility as introduced.
I believe Kiki's gonna rename that. So there's the as introduced version, and I put together a section by section summary
Oh, good.
because it's a pretty dense bill, and I thought it might be easier to look at the
Let's go
section by
through the
section.
section by
You
section.
wanna do that?
Well,
Okay.
don't you think that makes sense?
Sure.
And then we can go back through the bill another time. Just getting the concept, I think is good.
Yep, let me switch
Go ahead.
documents.
So Act 27 was passed, but there was no mechanism and no rulemaking, basically.
Act
Or
27.
funding.
Act 27 anticipated that there would be a forensic facility. It had intent language that the General Assembly still plans to go ahead and open a forensic facility as of July 1, 2024. It asked the departments to move forward with rulemaking that would be necessary to get the forensic facility open. But you're right, it doesn't have that piece that is actually how an application would be made to the court, how the court would have to make a decision on that application to place somebody in a forensic
So this
facility.
bill fixes that.
So this is language that you discussed. It was stripped out of Act 27, and this is sort of like how to mechanize the placement of a person in a forensic facility.
So is there a distinction between how a person is placed who has a mental illness and is involved in the judiciary as compared with someone with an intellectual disability and is involved with judiciary?
Yes, great
There's a
point.
difference.
So the bill, yes, we have two separate sets of statutes that govern the commitment of individuals with mental health condition and individuals with an intellectual disability. As with the bill that you looked at last year, this bill is almost divided in half. And the first part of the bill looks at the commitment of individuals with mental health condition. The second half of the bill looks at the commitment of individuals with intellectual disability.
Thank you.
Okay.
So the Act 27 working group that we looked at, and we looked at the report that Stuart Shore and Karen Barber and others spoke to, that report is with regard to folks with intellectual disabilities and how to work with them. And I've asked Kiki to put that report back up here with this bill as well.
This is your bill?
Is this my bill?
It is.
Okay,
It's just checking on
thank you.
The Senator Sears.
it.
Yeah, I did work with the judiciary on this one. And so is there a place in the summary that points out the potential crimes? Okay.
Yeah.
Okay, yeah,
No, I mean, there's never
not fully.
listed specific crimes, but there are dangerousness factors
Okay.
that the panel has to consider when making a recommendation, which we'll get to. Okay, so we're just gonna look at the section by section summary. We have a purpose and legislative intent section. It states that the purpose of the act is to enable the two commissioners, DMH and DALE, to seek treatment and programming for certain individuals in a forensic facility. And we'll talk about what population that is later. And this is consistent with the work that was already done last year. It further states that the intent of the General Assembly is that an initial forensic facility be authorized and be operational beginning July 1 of this year by repurposing that 9-bed unit within the Vermont Psychiatric Care Hospital. So the next portion of the bill we have pertains to the Human Services Community Safety Panel. So this is sort of a new concept that the Senate didn't spend a lot of time looking at last year. I think it spent a trying to remember my timeline, but I think the House took a deeper dive into this concept. So this establishes a panel within AHS, which is to be the entity that's responsible for assessing the potential placement of certain individuals with either a mental health condition or an intellectual disability in a forensic facility to the extent the individuals present a significant risk of danger if they're not held in a secure setting and are charged with a crime for which there is no right to bail. It lists who the members of this panel are. So there are 4 members of the panel, the Secretary of AHS, and then 3 commissioners of DOC, DMH, and DAIL. And then it provides the panel with the technical, legal, fiscal, and administrative support of the agency in those 3 departments.
So when you're looking at 13 VSA 7553 and 53A, 33 rather, is that where we would find the list of crimes then?
I have to go back and
Okay.
check the statutes.
Yeah.
Title 13 is the
Oh,
criminal title. It's a little outside my wheelhouse. So I've been working
Sure.
in collaboration with my colleague Eric Fitzpatrick.
So that second bullet, is that, charged with a crime for which there's no right to bail? Is that because they're not found mentally competent to stand trial?
It's the type of crime itself.
Any other questions there?
Yeah. Okay. So next we move into admission to the forensic facility who are persons in need of treatment or continued treatment. That is a term of art and statute. A person in need of treatment or continued treatment is referring to individuals who are being considered for commitment if they have a mental health condition. So we first have this language in Title 13 that specifies that once a report addressing a defendant's competency or sanity is completed or disclosed, the panel we just talked about, can conduct a review on its own initiative. So I'll flag for you that that's in May. They don't have to conduct a review, but they could conduct a review on their own initiative regarding the placement of an individual in a forensic facility. If the panel chooses not to initiate its own review, a party to a commitment hearing may file a written motion to the court requesting that the panel do a review anyway, within 7 days of receiving the competency or sanity report or within 7 days of the individual being adjudicated not guilty by reason of insanity. So the panel can do its own report or review because it initiates one. If it doesn't initiate one, another party could request to the court that this panel do the review anyway, in which case the court would make a ruling. The motion must specify that the individual who is the subject of the proceeding is charged with a crime for which there's no right to bail, and may include an individual who's adjudicated not guilty by reason of insanity, and that the person is a significant risk of danger to self or the public if not held in a secure setting. And then this language requires the court to rule on the motion within 5 days. And if the panel review is ordered by the court, it must be completed and submitted to the court at least 3 days prior to a commitment hearing.
So in a practical sense, can we talk about how this, what's happening here with,
Yep.
with the person? Yeah.
Okay, so this language is pertaining to a person who has either already been adjudicated not guilty by reason of insanity, or there was a competency evaluation and the person conducting the evaluation has said this person is not competent to stand trial. They can't understand the charges against them. They can't participate in their own defense. They're not competent. So at that point, the review panel could proactively choose to do a review of whether this person is a candidate for the forensic facility. Other criteria have to be met, right? That this person has to have a mental condition, they have to have an intellectual disability, they have to have been charged at least with a certain crime, there's a level of danger there. But in those situations, the panel could say, we're going to conduct our own review and come up with an assessment of whether this person is a candidate for the forensic facility. If the panel says, you know, we're not going to do a review in this particular situation, that doesn't mean that there's no review conducted. There could still be a party to the proceeding who thinks there should be a review, in which case they'll petition the court and say, court, we think there should be a review. Here's why we think there's a review. The court would make a decision on that petition, and if the court believes, yes, a review really should be done in this case, then the panel would still have to go through and do the review and submit it to the court. Okay, so if a review is done by the panel, regardless of whether they're doing it by their own initiative or by a court order, there are certain things that the panel has to consider. They have to consider some clinical factors, and they have to consider some dangerousness factors. So with regard to the clinical factors, the panel is going to look at whether the individual is served in the least restrictive setting to meet the individual's needs, and the individual's treatment and programming needs are going to dictate that the treatment or programming be provided in an intensive residential level. So those are the clinical factors. They want to make sure that the forensic facility is the appropriate clinical placement for the person.
Can you talk very briefly about the types of settings that might be available other than a forensic facility?
Okay, so when you're at a point, I'm going to use an individual with mental health as sort of our example, but a forensic facility placement, as we'll see later on when we continue to walk through this, requires a certain level of clinical and medical need. So it's not just that a person has committed a crime and has a mental health condition. It's also that on assessment, this person needs a high level of treatment, and that they are meeting a clinical level of need to enable the state to require that they're treated in a certain facility. There are a few different types of orders that a court could make. A court could decide to commit a person to the commissioner of mental health on an order of hospitalization, in which case they would not be at a forensic facility. But if the court says, you know, this person still needs care, they still should be in the commissioner of mental health custody, but they don't need to be in a hospital level care, they could be on what's called an order of non-hospitalization. An order of non-hospitalization, it's a really big spectrum of what that could look like. It could be treatment in a facility, like a forensic facility. That would be one option if this bill were to be passed. But a person could also be out in the community receiving treatment in the community on an order of non-hospitalization. So that's a really big spectrum. Could I just answer your question?
Yeah, this is very good.
Okay.
I think, you know, there could be a facility that is, if it's out in the community, it could be supported by one of our designated agencies. It could be more of a home environment. So that broad spectrum could send them back home with a caretaker.
Yeah.
Yeah.
So the idea of adding to allowing or creating a process for a forensic facility is like adding a type of care to the spectrum of what a person could receive when they're on an order of non-hospitalization. And you're putting kind of specific parameters around who could be at a forensic facility in a way that maybe some of the other options don't have the same kind of constricting type of parameters around who would receive treatment there. Okay, so we've talked about clinical factors. The panel is also going to take into account dangerousness factors, and those are listed in the bill. So the factors include whether the individual has inflicted or attempted to inflict serious bodily injury on another, has attempted suicide or serious self-injury, or committed an act that constitutes sexual conduct with a child, or lewd and lascivious conduct with a child, and there is a reasonable probability that the conduct will be repeated if admission to a forensic facility is not ordered. The panel will look at whether the individual has threatened to inflict serious bodily injury to the individual or others, and there is reasonable probability that the conduct will occur if admission to a forensic facility is not ordered. The panel will look at whether the results of any applicable evidence-based violence risk assessment tool indicates that the person's behavior is deemed a significant risk to others. The panel will look at the position that the victim takes and also other parties to the criminal case and any other factors that the panel deems relevant to the assessment of risk.
So the determination of this rests with ultimately the information is at the panel. But so for example, the evidence-based violence risk assessment, who does that assessment? Is that something that's done within the judiciary? Is that something that's done by the panel? That's done by the panel itself? Or does the information come to the panel from an external?
I would assume it's not the panel themselves who are doing that they would have an evaluator doing that. But you have the two experts, so I would defer to their expertise on how and when that panel.
Can we ask that question?
Please.
So Stuart Shure or Karen Barber, did you hear the question?
Yes, Senator, this is Stuart Shure. Good morning. I did hear the question, and while the proposed bill doesn't specifically speak to which experts the commissioners, the panel members would rely upon, it would be my understanding, and Karen, please weigh in, would be that the commissioners and the secretary would rely on that expertise, whether it be internal or external, in order to make that recommendation to the court. So that would be one of the requirements, which could be more explicitly stated in statute or could be implied that the expertise would be relied upon by the panel members.
Okay, so we'll look at the language when we go through the bill, but it does make sense to give some latitude to the panel in deciding what information it needs to gather.
Karen Barber, General Counsel for DMH. I would just add that there's not really any evidence-based violence risk assessment tools in the mental health realm. This was more applicable to folks in Dale's custody. So just kind of want to make clear that there's not necessarily a tool out there that DMH uses.
Okay.
Which is why it says if applicable. Or
there is a tool. I'm sorry.
There is not.
I interrupted you. Go back and say what you said again, please.
There is not one in the mental health realm, which is why it says any applicable, because we don't have a tool that we give folks to determine whether or not they go out into the community. There is nothing like that really is in the mental health world.
But there is something applicable within the intellectual disabilities realm.
More so, and I'll let Stuart speak to that.
Yes, to the extent that we have an evidence-based assessment tool, that would be something that we would use. But again, these are factors that the panel would need to rely upon in order to make its best case for placement in the facility. So ultimately, this decision is up to the court. But it would be in the interest of the departments and the panel, if it believed that the individual should be placed there, to rely on all the tools that were available, whether it be an evidence-based assessment tool or the expertise of individuals.
Thank you both.
Sure.
Do we have any idea about the makeup of this board? Is it going to be state employees? Is it going to be privatized?
The panel that's making the decision, it has 4 members: the Secretary of Human Services, the Commissioner of Mental Health, the Commissioner of Dale, and the Commissioner of Corrections. Those are the only 4 people. I do think it's important to just sort of emphasize what this panel does and doesn't have authority to do. Just because the panel makes a recommendation that a person should be in a forensic facility, that alone does not make it so. That's a recommendation. It's a recommendation to the Commissioner of Mental Health or the Commissioner of Dale, as to whether they want to file an application with the court to request that the person's in a forensic facility. A court has to make that decision ultimately to order a person in a forensic facility.
Thank you.
Okay. So I'm going to move off of this language about the panel. And now we're in Title 18. Again, the first half of this bill is focused on individuals with a mental health condition. In Title 18, Section 4, we're adding a definition of forensic facility. This has not changed since you saw the bill last year. But a forensic facility means a residential facility licensed as a therapeutic community residence for an individual who's initially committed under 13 VSA 4822, which is insanity as a defense, a person with mental illness. So this is a person who is in need of treatment or further treatment in a secure setting for an extended period of time. And then sort of the partner to 4822 is 4823 for a person with intellectual disability who is in need of custody care and habilitation in a secure setting for an extended period of time. So those are two people who are committed under the criminal Title 13. It's worth noting because this caused confusion last year, and I'm sure it will cause confusion this year. So a forensic facility will be licensed as a therapeutic community residence. A therapeutic community residence is a license type that is administered or managed by Dale. So it is completely possible that a facility that has no individuals with intellectual disability, a therapeutic community residence, even though it's licensed by Dale, could have people who only have a mental health condition there. And we have other examples of that. We currently have a secure residential recovery facility, which I'm 95% sure is licensed as a therapeutic community residence. So it'd be licensed by Dale, even though it has individuals in the custody of the Commissioner of Mental Health there. It's just the license type.
Where is that facility?
I'm gonna let Karen take that one.
No. We'll hold that for.
River Valley is
Yeah.
where Woodside used to be, so it's in Essex.
Oh, okay, it's the River Valley. So, and FYI, this committee would really enjoy a visit at our field trip. So we'll set that up at some point.
Sounds great.
Essex. Okay.
Okay.
Yeah, it is. Right across the street from the fort.
So before I walk you through this next before we look at the actual language of the bill and go through the section by section, I'm just going to remind you of the process of how the Commissioner of Mental Health would apply to have somebody in their custody. And then this language sort of inserts the forensic facility as an option into this process. So first, the Commissioner of Mental Health would submit an application for involuntary treatment to a court. Involuntary treatment can be confusing with the word treatment. I think sometimes we think medication automatically, but this is an application for commitment into the care and custody of the Department of Mental Health, the Commissioner of Mental Health. The court will look at this, and the court will make an order that the person doesn't meet a clinical standard of care, doesn't have that level of need, and the application might be dismissed. It could be that the court looks at it and says, yes, this person should be on an order of hospitalization. Their level of need, their clinical need is so high it can only be addressed in a hospital level setting. It could be that the court says, yes, this person does need care in the custody of the commissioner. Their clinical level of need is not high enough to need a hospital level of care. I will order them on an order of non-hospitalization, and that is that spectrum that we talked about, that it could be that the person is receiving care in a community-based setting. It could be more intensive when they're in a residential setting. It could be the secure residential recovery facility. It could be, if this passes, a forensic facility if the person meets certain criteria. The initial order is for 90 days. up to 90 days. And after that, if the commissioner believes that the person still needs treatment past the initial 90 days, they can submit a similar application, an application for continued treatment to hold the person for longer, which goes through a similar court proceeding where the court makes a determination, yes, the person needs continued treatment in a hospital or an order of non-hospitalization, or no, this person no longer has this clinical medical need and they don't need to be in the custody of the commissioner.
If they do remain in that location, does it continue to be these 90-day increments?
The continued treatment is up to a year.
Okay.
An order up to a year.
So they're, for lack of a better term, they're committed to the forensic facility via panel. Then 90 days later, no.
No. So the panel is just making a recommendation as to whether a forensic facility placement is appropriate for a certain population of people. So if a person has a medical need for treatment, there's an application made to the court. The commissioner of mental health at that point may believe that this person is a candidate for a forensic facility based on the review that was done by the panel. So that panel recommendation is going to be given to the court when the court is making its decision about whether to place somebody in a forensic facility. But the panel cannot make the placement. The panel can only make a recommendation. It's only the court that could order somebody to a forensic facility.
So essentially, we're talking about people who have been charged with a crime. They haven't necessarily gone through the court process.
Not
yet.
necessarily.
This is kind of pre-trial, or
I mean,
is it post?
It includes
Can be
people
both.
adjudicated not guilty by reason of insanity, but it could include people, and probably most often would include people who haven't gone through with the trial. There'd be, they're charged, and then there's a competency evaluation, and it becomes clear before the proceedings are underway that the person cannot understand the charges against them. They cannot participate in their defense, and so legally they're incompetent to stand trial.
Is there any kind of data as far as the number of beds would be required? How many people do we have right now that would fit into that?
Those would all be good questions for the department.
Okay, thank you.
Yeah, well, we'll bring them in on the bill. Unless, do you want to answer the question now, either Karen or Stuart, or both?
That's something, at least on the DMH side, we'll have to get back to you on. Sorry.
Okay, terrific. Yep, thanks.
Yeah, and I would agree with Karen. I mean, at this point, we're talking about very few individuals, and the need for medication for any one particular individual is not something that I could respond to today.
Okay, thanks. Yeah, so when you come in to testify on the bill, it will be helpful to have some of that information so we get an understanding of numbers of folks. I mean, we read the newspaper and we see what's going on, but we don't know the full population. Do you want to make a comment?
Yeah, for the record, Rebecca Silvernagle, I'm principal assistant at Dale. From the last information I received, we had 29 people who were committed to the custody of Dale. And out of those 29 people, one is in the custody of DOC. So I don't know if that helps.
It does, very much so. Thank you.
Okay. So I just gave you sort of an overview of what commitment in the mental health context looks like. So now the next few sections sort of walk through the mental health commitment statutes and plug in this option for a forensic facility as one of the choices that a court could order. So first, section 5 is the application for treatment. That's the commissioner of mental health or designee submitting a motion to the court saying that this person should be in the care and custody of the commissioner of mental health. So we have some updated gender neutral language in that section, but it adds a new subsection G that requires the commissioner to specify in the application if the commissioner plans to seek to have the person treated in a forensic facility, including the reasons why this placement is clinically appropriate and why treatment can be provided safely only in a forensic facility, and including the recommendation of the panel. So,
So this is in addition to any panel recommendation?
yes.
So it's the Commissioner of Mental Health also making a separate recommendation or with
Or
to the,
request.
a request?
Yeah.
A request, okay. So just to make sure that that's clear,
Yeah, so I think what this is really saying is, the court can't just sort of on its own initiative receive an application about a person for commitment and say, huh, I bet this person would do well in the forensic facility.
Yeah.
This says that, the commissioner, when they're putting the application in for the person to be, in the commissioner's care and custody, has to specify in the application, this is where I would like the person to be committed. That doesn't mean the court has to accept it, but the application itself has to state that request, that they're looking for treatment in a forensic facility. Why a forensic facility? Why is this the appropriate placement for the person? And also, the whole panel did a review on this, and this is what the panel is recommending court. That is all sort of part of the package that's coming into
checks
the
and
court.
balances, yeah.
Okay, so after the application has come to the court, there's a hearing on the application. Some new language here, so new subdivision A3 that allows the applicant or person for whom an order of non-hospitalization at a forensic facility is sought to file a motion for an expedited hearing. There's, this isn't unique to a forensic facility. There's already an option in statute for an expedited hearing for commitment. So if there is a motion for an expedited hearing, specifies that the court shall grant an expedited motion if it finds that the person demonstrates a significant risk of causing the person or others serious bodily injury, and clinical interventions have failed to address the risk of harm to the person or others. So that's a shall. And then secondly, the court may grant the expedited hearing if it finds that the person has received involuntary medication in the past 2 years, and based upon the person's response to previous and ongoing treatment, there's good cause to believe that additional time will not result in regaining confidence. If the court grants an expedited hearing, it will occur within 3 days of the order, and the court may grant an extension to allow for a psychiatric exam. So this is more technical about the timelines and when a timeline can be sped up for the hearing. Okay. And then we have section 7, which is the order itself, the court making a decision about the order of non-hospitalization for that particular person. So the bill adds a new subdivision A2 to this section that states that if the Commissioner of Mental Health determines that treatment at a forensic facility is appropriate, and the court finds it is the least restrictive setting adequate to meet the person's needs, the court shall issue an order of non-hospitalization at the forensic facility for 90 days, or up to 90 days. And the court may review need for treatment prior to the expiration of the order. So this is sort of just saying now forensic facility is also an option for an order of non-hospitalization. And this tracks with what happens on other orders of non-hospitalization, in that the order can be up to 90 days, and prior to the expiration of the order, the court can review the need for treatment.
So it adds something within that broader non-hospitalization spectrum. And are all of these options for up to 90 days, or is it only the forensic facility?
All initial orders are for up to 90 days,
Yes.
and then the continued orders are for up to a year.
Okay.
Unique to the type of facility that a person, or community treatment where a person is receiving treatment.
This bill uses the language least restrictive quite a few times. I'm wondering, what are examples of more restrictive settings? Is it just incarceration, prison? Or
Prison would, so we can talk about that in terms of Go ahead, Katie.
Okay. So the reason that language comes up so much is because it's a standard, a US Supreme Court standard, the Olmsted standard, that people have to be treated in the least restrictive setting to meet their needs. So it's sort of balancing a person's clinical needs and their risk of dangerousness. So could be that a person is quite dangerous, but they're not meeting certain medical standards. So there might be an inclination, were this standard not in place, to have them treated at a high level restrictive kind of lockdown care, even though clinically they don't need it. So it's recognizing the clinical level of care that somebody needs and balancing their clinical level of need and their dangerousness, risk of violence, to ensure that they're being treated at a facility that is not restraining civil liberty any more than necessary.
Right, but it's safe to say there aren't many facilities that are more restrictive, correct?
Well, I mean, we have secure residential recovery facilities. Are you meaning more restrictive than the forensic facility?
Yeah.
I mean, yeah, an incarcerated setting would be more restrictive.
But the point of going toward a forensic facility is that putting someone in jail who needs intellectual disabilities treatment or mental health treatment, jail is not the appropriate setting.
Yeah, no,
And that's
I
what-
get
that's
that.
what- Yeah,
Yeah.
so that's.
Yeah, I'm just trying to understand
Yeah.
what all the different,
Yeah.
possibilities are,
Yeah,
but thanks.
and it might be worthwhile to hear from the department, what the range. What is the spectrum that we're talking about when we talk about an order of non-hospitalization? And what are the locked facilities? What are non-locked facilities
Right.
look at? What is physically secure versus staff secure versus a facility that, a person would be free to come and go in the community, and sort of better understand those options.
Great.
So I don't know if the bill says, I'm going back to section 7. It's,
We're not there yet.
okay, oh,
No, it's okay. I'm
Well,
on
you
section
said-
7.
Oh, we're back to seven. Oh, back to seven, I got it.
so
Yeah.
it says, court shall issue an order for 90 days. You said twice up to 90 days. Is
Yes,
that- does
so
it-
it's up to 90 days in statute.
Okay, so the order says, or the bill says not up to 90 days.
Up to 90 days. I'll confirm that it does.
And we'll go through the language and then, a good question.
Yeah. The idea is that if a person also needs hospital level treatment or, for 45 days, the order wouldn't be for 90 days.
That's a great question, Senator, because I think it does say, it always says for a period of 90 days, not up to 90 days.
Is
Interesting.
that in the bill?
That's
It's
in the-
both in the current law language and in the new
We'll
language.
I'll have to
double,
look at that.
Katie will double check that.
Words matter.
Yes.
It was, the comments that were made consistently during the workshop, working group, Act 27 was up to.
Up to. And I met with Karen on an unrelated matter last week and she reminded me it was up to.
Up to, so we'll have to make sure it's in. Thank you, Senator Williams.
Okay. So, we'll keep moving along. Section 8 is an application for continued treatment. So this is the person has already been on their initial order of up to 90 days, becomes clear to the commissioner that the person will need continued treatment, that the initial order is not long enough. This section authorizes the commissioner to submit an application for continued treatment, to continue treating the person, continue holding the person in the commissioner's custody. And the language in the bill specifies that an application for continued treatment for a forensic facility must expressly state where treatment is being sought and why the Commissioner of Mental Health has determined that clinically appropriate treatment for the individual's condition can only be provided safely in a forensic facility. So sort of the same information they provided when the person was initially committed. And it also directs that the application for continued treatment must include the panel's recommendation. So just
So
like,
the application for continued treatment comes from whom, or does it come from the panel? Does it come from,
it generally comes from the commissioner. Yeah,
mental
it comes
health
from
in this
DMH, that they already have this person in their custody, and the person is still has a clinical need for medical treatment, so they file and sort of the next step of an application to continue holding that person, or caring for that person. Not necessarily, just because we say custody, as we said, the person could still be out in the community. Okay, section 9. This is the hearing on the application for continued treatment. It authorizes the court to place an individual in need of further treatment on an order of non-hospitalization at a forensic facility. So this language just authorizes the court to use that new option in the spectrum of orders of non-hospitalization. Section 10, this is something we haven't really discussed yet today, but you looked at it last year. So an application for involuntary medication. We talked about how sometimes the title and application for involuntary, or an application for treatment, for commitment, that title can be kind of confusing, because when we hear the word treatment, sometimes we assume that involuntary medication is being given to the person, and that's not the case on an application for involuntary treatment. If it's believed that a person would benefit from involuntary medication, there is a separate application process that goes through a court. And section 10 describes that an application has to be filed generally by the Department of Mental Health, who already has this person in their custody, recommendation as to the type of medication that the person should receive, the dosage, how long, and a court has to make a determination as to whether that person should be receiving that medication. There are lots of factors that the court's going to look at. The court's going to look at whether the person has an advance directive that already speaks to this issue, whether the person has any competently expressed statements, either verbal or in writing, about their medical preferences, but the court is going to make that decision. So the language in the bill, section 10, allows the Commissioner of Mental Health to seek involuntary medication for an individual who's refusing to accept psychiatric medication, who has been placed under an order of non-hospitalization at a forensic facility, or who has an application for involuntary treatment at a forensic facility pending, for which the court has granted to grant an expedited hearing. This is noteworthy in that, for the most part, involuntary medication is provided in a hospital setting. So this is not a hospital level setting, but this change would authorize involuntary medication at this setting. Section 11, this is the court findings with regard to the involuntary medication application. So it adds a new subsection O, that if the court finds that without an order for involuntary medication, there is a substantial probability that the individual would continue to refuse medication, and as a result would pose a danger of harm to self or others, the court may order administration of medication at a forensic facility for up to 90 days or longer if necessary.
So that covers both the initial 90 days and then the up to a year? Is that what that's covering, or I'm trying to sort that one out?
Perhaps, if I'd have to go back and look at the language. I'm only looking at my notes. But longer if necessary would be if the person's under an order of continued treatment that's for longer than 90 days, maybe the order for medication would be longer in that case. And then there's language that if the individual becomes competent, the order is no longer in effect. That's the way the law stands now. It wouldn't be different for individuals in a forensic facility. If a person is competent to express their intentions about medication, then involuntary medication can't be administered, even if there was an order. The order sort of ends at that point. Okay, so we're shifting gears. That all pertain to individuals with a mental health condition. And so now we're moving into individuals with an intellectual disability. So the term of art here is a person in need of custody, care, and habilitation, or continued custody, care, and habilitation. Those are the statutory terms. Somebody who's committed to the Commissioner of Dale, different from mental health, which was a person in need of treatment or a person in need of continued treatment. One thing you'll sort of know about the statutes is the mental health statutes are a little bit, I don't know what the right word is, methodical or fleshed out a little bit more than the commitment statutes and for individuals with intellectual disability. We'll take a look at that as we go through. Okay, so first we have changes to the statute in Title 13, the criminal statute. This specifies that if an individual is committed to the Commissioner of Dale, that the placement must be in a designated program in the least restrictive environment consistent with the individual's need for custody, or for an indefinite or limited period of time. It replaces language that cross-references sections repealed by this bill with provisions that judicial review procedures for an order issued under this section and for discharge from a commitment must be in accordance with 8845 and Title 18, which we'll look at further down. And new language that if the commissioner is seeking to have an individual placed in a forensic facility, the commissioner must provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only at a forensic facility, including the recommendation of the panel. So this is very similar in that if an application to a court is being made, the Commissioner of Dale thinks that a person needs to be in their care and custody and that the appropriate place for treatment is in a forensic facility, the application to the court has to specify that this is what the commissioner is asking for, treatment in that facility. And it also has to have the recommendation of the panel going to the court. So again, the panel is not making the decision to put somebody in a forensic facility. They don't have that authority. It's only a recommendation they're making, and the court has the authority to choose to place a person in a forensic facility.
So it's parallel tracking with the Department of Mental Health, the person with the mental health.
Yes.
Yeah.
Yes, it's trying.
It's trying to track.
The
so
statutes are
slightly different place.
Yeah, the statutes are very different from each other, the structure of the statutes, but it's trying to track that, yeah.
Go ahead.
Yeah, I missed the beginning of the bill, so maybe you covered this. Is the Human Services Community Safety Panel a new thing, or is that an existing?
Yes.
It's a new thing.
It's new, it's proposed
Maybe
in
just
section 2
share
of this
the
bill.
membership.
Yeah,
okay.
So the concept is that it's a panel of the Secretary of Human Services, Commissioner of Corrections, Commissioner of Mental Health, Commissioner of Dale, and those 4 people can make a recommendation about whether a placement in a forensic facility is appropriate. They can initiate a review on their own initiative, on their own prerogative. But if they decide not to do a review, there's a court petition process to require them to do a review if a court thinks it's appropriate for them to be doing a review.
Okay.
And then if the request is for a person to be in a forensic facility, either by DMH or Dale, the recommendation of the panel has to come along with the application materials, has to be part of the motion to the court.
Okay, so for both people with mental health or developmental disabilities, it's the same, or intellectual disabilities, it's the same panel?
Yes.
Dale and DMH are on both,
yes,
regardless of the person? Okay.
Yes.
Okay.
Good. Okay. Section 13, we're making changes to our definition sections. So it's removing the definition of danger of harm to others. It's adding a definition of commissioner and person in need of continued custody, care, and habilitation. And it amends the existing definition of person in need of custody, care, and habilitation. Okay. And then it removes sections 14 through 17, repeal for statutory sections, 8840 through 8843 of Title 18. And I've pretty much butchered this explanation every time I've given it. So I'll try again with Stuart's help. So those 4 sections are what the department is sort of calling form without substance. 18 VSA chapter 206 had subchapters 1 and 2 repealed in 1995. And they used to provide a separate mechanism for an interested person to petition the court for state supervision of a person with intellectual disability who presented a danger of harm to others. That piece was not repealed and remains intact. Despite its apparent structure, subchapter 3 does not provide an independent avenue for seeking a civil commitment. And in the absence of having subchapters 1 and 2 along with subchapter 3, it doesn't make sense to retain 840 through 843. So the idea is that subchapters 1, 2, and 3 were sort of a package that worked together. Subchapters 1 and 2 were repealed, and without 1 and 2, 3 doesn't work on its own as a course of civil commitment. So that is why there's a proposal from Dale to remove 840 to 843.
Okay, and we'll hear from Dale.
Hopefully Stuart can correct me if
Stuart
I've
can
misspoken.
Elaborate, yeah, good.
I'm happy to do that whenever you're ready, but I think you did a fine job, Katie. Basically, I would say that if you look at the sections that the department is seeking to have repealed and are proposed to be repealed here, they reference a lot of those sections in subchapters 1 and 2, which were, as Katie said, were long ago repealed. So it really doesn't make any sense to have sections in there that reference old repealed subchapters of this chapter. But the content, or much of the content in those repealed sections, where applicable, would be moved to the meat of this chapter, which is in section 8845. And I think that's where Katie's going to take us next.
Thank you for that.
Thank you. Okay, so we're moving to section 18, which pertains to legal competence. This specifies that a determination that an individual is in need of continued custody, care, and habilitation does not lead to a presumption of legal incompetence. And then we move to section 19, which is judicial review. And most of the changes are in this section, so it's a bit dense. And subsection A, we have
And the rest isn't dense. Great, thank you.
Oh, I know, it's all a bit complicated. So subsection A has a couple changes. First, it specifies that individuals who are committed to the custody of the Commissioner of Dale under Title 13, our criminal justice title, may be discharged from custody after judicial review by a superior court in accordance with this subchapter. Also, it directs that at least 10 days prior to the effective date of any administrative order for discharge by the commissioner, that the commissioner gives notice to the committing court and the state's attorney of the county where the prosecution occurred that discharge is occurring. So this is not specific to a person in a forensic facility. This is language that pertains to commitment generally for individuals in the custody of the Commissioner of Dale.
So the whole spectrum.
Yeah. Subsection B specifies that individuals who are committed to the custody of the Commissioner of Dale under Title 13, our criminal justice title, are entitled to a judicial review of the person's need for commitment annually, and that the family division of the Superior Court has exclusive jurisdiction over these judicial reviews. If a judicial review is not requested by the individual within 1 year from the date of the last review, it will be initiated by the commissioner automatically. So if the person doesn't ask for a review within a year, the commissioner has to do it. An individual may initiate a judicial review after 90 days of initial commitment, and after 90 days of an order for continued commitment. So a person doesn't have to wait for a whole year to have it reviewed. After 90 days, they can ask for that review.
So an individual with an intellectual disability,
Mhm.
how would they know that? So who's advocating?
They would probably have an advocate, in the context of mental health. Vermont Legal Aid does most of the commitment proceedings. I'm guessing that Vermont Legal Aid might do the commitment proceedings also for, individuals with intellectual disability, but I'm not as certain on that, and I would,
We'll get
thank
testimony on
you,
that.
Stuart just popped on. Stuart's in a better position.
Yeah,
Yeah.
really quickly, by statute, Vermont Legal Aid is tasked with representing individuals at the initial commitment hearing and also at these annual reviews. That came to a surprise. To the surprise, we learned during the working group of the legal aid representative who was representing the Vermont Legal Aid's Disability Law Project, because it appears that the Mental Health Law Project is representing individuals, whether they have a mental illness or whether they have an intellectual disability. So I do believe that Legal Aid is in fact representing all individuals at their commitment hearings and at the annual reviews. But that is the state of the law. That is the role of Legal Aid, to represent them.
So we have adequate resources to do everything with these changes?
They should. We'll ask that question, remembering that we're not talking about a huge group, but it is a delicate group, no question. And the timing is important.
Okay. So subsection C specifies that if the Commissioner of Dale seeks to place a person who's committed under the subchapter, so committed to the Commissioner of Dale, in a forensic facility, the petition must expressly state that the placement is being sought in a forensic facility, set forth the reasons for the Commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility, and what the recommendation of the panel is. So that should seem pretty similar to what we've already said, that when we're requesting, when one of the commissioners is requesting a placement in a forensic facility, they have to state why this is the appropriate setting, that they are in fact asking for the forensic facility placement, and what the panel has recommended on that point. Subsection
programming is recommended as well. I mean, that's something that we went over in here last year. So,
and I think you're getting a presentation on programming proposals. When is that? The February 15th comes to mind that you're supposed to be getting a presentation from the various committees, or the two departments on programming and staffing for the forensic facility. Okay. Subsection D is more technical. It directs that the Vermont Rules of Evidence and Procedure applicable to civil cases apply in these judicial review proceedings. Subdivision E, subsection E, not subdivision, directs that the Commissioner of Dale or the Commissioner's designee attends the commitment hearing and is available to testify. It specifies that all persons to whom notice is given may attend the commitment hearing and testify, except that the court has the authority to exclude those persons who are not necessary for the conduct of the hearing. Subsection F require.
Just before you go ahead.
Yeah.
Civil commitment and then criminal involvement. Can you just talk briefly about that? Should we?
Sure.
Yeah.
Well, when I think of civil commitment, I'm thinking that the person is in the mental health context. It's they have a clinical need for treatment, so that's why they're receiving a civil commitment, regardless of any charges they might have pending. Their medical need is being treatment, and similarly for somebody who is in the custody of Dale. If they're being committed to the custody of the Commissioner of Dale, it's because they need certain treatment or certain programming. When we talk about somebody's criminal involvement. It doesn't mean somebody necessarily doesn't have criminal involvement, but they're maybe in the position they are because they weren't competent to stand trial in the first place, meaning that they couldn't participate in their court trial. They couldn't understand the charges that were being brought against them. And that's why they're sort of being taken out of the criminal process to receive the treatment or programming that they need. Does that help?
Yeah, no, it's fine. I'm just that there is a distinction there, and you know, maybe as we go forward, I'm wondering whether you and I can talk about whether or not we need Eric Fitzpatrick, because I'm feeling like we're getting a really good, a solid.
Well, I mean, Eric is going to be very helpful, especially, we can talk about this a little bit more, but were I to hazard a guess, if the committee decides to move forward with the proposal that's on the table, it's the first part of the bill on mental health.
Right.
It seems that those provisions were feeling like there was more consensus that was being gathered around the language there and the mechanism would work. There might be more fine tuning that would need to be done in the intellectual disabilities language. And if that is the case, we might pull Eric in on some of the court procedures.
Yeah.
I think he would be useful.
Okay, thank you.
His expertise would be useful there.
We'll do that.
Okay. I had something else I was gonna add and it has, I slipped away. That's okay, it might come back. Subsection F. This requires that if the court finds by clear and convincing evidence at the time of hearing that the individual is in need of continued custody care and habilitation, commitment shall continue in a designated program in the least restrictive environment, consistent with the individual's need for custody care and habilitation for an indefinite or limited period of time. Otherwise, the individual is discharged.
So can I ask?
Yeah, go ahead.
I know it's not a change, but this term for an indefinite or limited period of time seems murky. Like it could be for indefinite means kind of like without an end, and it's not really defined. And then limited period isn't clear either.
I hear the concern, as you said, it's not a change.
Yeah.
It would be interesting to hear from the department how that's been used. It might be worth the committee looking at creating a structure that mirrors commitment in a mental health context. Those are policy questions.
Okay.
So Stuart, did you hear the comment?
I did. Can you hear me?
Yes.
Oh, okay. So yes, I did hear the question, and we did hear some comments during the working group meetings about this, and it was the advocate's position, for example, that this language was unnecessary, that the extended period of time, if in fact the purpose of a forensic facility is for a short-term placement or for a period during which the individual needs this higher level of care. But at this point, historically, that has not been an issue of dispute in the courts. The duration of an order of commitment to the commissioner's custody has been determined by the court during the annual judicial reviews. So it's a statement indicating that these orders of commitment can be for a month or they can be for years. I think that's the purpose of that language there. I don't know if it's particularly instructive or necessary to have it because, as I said, the courts generally determine when the order should be vacated or the individual is no longer needs the commitment.
Thank you. And so this will be something that we'll have to have testimony, continuing testimony going forward, and to fully understand the custody issue overall.
Seems vague.
Yeah, we did spend a lot of time on this, and whether it needs to be changed or left, let's see. Okay.
Subsection G. Determining whether an individual is in need of continued custody, care, and rehabilitation requires the court to consider the degree to which the individual has engaged or complied with treatment and supervision provided by the commissioner, as well as the panel's recommendation. Excuse me. So that one section is really where we have a lot of our commitment, all of our commitment language.
It's all right there.
So as I was saying, a very different structure from sort of the statutory framework in with regard to mental health commitments.
So I will say that when I asked Katie to draft the bill, I initially suggested that we use the mental health as a model. And then having gone through the working group and listened to folks on the working group, I switched it. So it's different. And it corresponds more with some of the concerns that we heard in the working group. So we'll hear testimony on this and try to, there may be some increased parallelism. I don't know, is that parallelism a word? Yeah, continuity between the two, we'll see.
Okay. So now we're nearly at the end. We have rulemaking language. A lot of the rulemaking language was in last year's Act 27. So what remained was that by 4/1/2024, so a little bit tricky date depending when this would actually pass, directs the commissioners of mental health and Dale to file initial proposed rule amendments that account for the establishment of a forensic facility with regard to therapeutic community residences, to allow the use of emergency and voluntary procedures and the administration of involuntary medication at a forensic facility. So there's sort of a lot to unpack there. So first, regardless of whether it's your policy decision that individuals with intellectual disability would be at a forensic facility, Dale will still be involved in this rulemaking, because as we said before, therapeutic community residences are licensed by Dale. It's in the creation and regulation of therapeutic community residences is a rule that Dale has written in. So they would be involved in that rulemaking procedure, regardless of what your policy decision is. To allow the use of emergency and voluntary procedures. So emergency and voluntary procedures have to do with seclusion and restraint, whether the restraint is physical restraint or chemical restraint, but it's for uses in emergency situations. And it's not exclusive to individuals with, let's say, a mental health condition. You could be at a general hospital in the emergency department, and depending on, what a situation is, an emergency and voluntary procedure might be used to address an emergency situation. And then also, as we discussed before, the administration of involuntary medication at a forensic facility. Right now, the involuntary medication isn't allowed at other therapeutic community residences, so this would be kind of creating an exception for involuntary medication to be used at this, not any type of therapeutic community residence, but this new type of community therapeutic community residence that would be a forensic facility. Effective dates, we have this rulemaking and the effective date section itself taking effect on passage, and then everything else takes effect July 1, 2024. So you might have to consider how that timeline would actually work for lots of reasons. The rulemaking piece, rulemaking is going to take a while. The likelihood of having a bill out and passed by July 1, when the rulemaking is supposed to happen, is unlikely. but not impossible. And then also having having the statute sort of take effect on July 1, which is the same date you're anticipating the forensic facility to be operational. There might need to be a conversation there about if there's lead time needed. So anyway, some thought to the timeline.
There's lots of stuff in there in the timeline, yeah, right. And then the other thing is on the procedures, with regard to licensing and operation and programming. I mean, there's, in terms of the rules, we may want to think about some qualifications to include within the rulemaking process. We'll have to think about that. Okay. All right, questions at this point? It's been good. This has been very helpful going through the section by section.
Okay,
First,
great.
really great. And thank you for putting it together in that way. Super. So what I'm going to suggest is we've got a half an hour, and then we have a question first.
So it looks like we're kind of wrapped up on briefing this particular bill. I have a question.
Not yet.
Oh,
Yeah, no, but
okay, my question's more generic.
Oh,
So given that this is a nine-seat, 9-bed facility,
Mhm.
I'm just curious of what and how we determine what the most cost-effective way is on setting up new facilities, given small state, neighboring states. And again, I'm new to this, so I'm just kind of, any kind of background brief would be.
okay, so we'll get that for you. I know that there's a lot of work going on in institutions, on both sides of the, House and Senate on this issue, and there's also discussion going on in judiciary. So having an update on forensic facility overall might be helpful. Maybe we could get Jennifer Fitch in, and maybe Nicole, do you have something you could provide with it? That would be great. So we'll do that when we take testimony on the bill. We can have sort of the precursor to testimony will be on where we are with this 9-bed carve-out facility.
Okay, don't get me wrong, I fully understand the need for the facility, I fully understand
Yeah.
all of the boundaries you created around it. I just wonder, whether it's cheaper to go, 40 miles one direction or the other.
We'll find out. Yeah, there's a lot of conversation that's been going on now for more than 2 years, more than 3 years. So it's yeah, you got it. Good deal.
Related.
Really.
We have the certificate of need process, and just to remind you that last year in Act 27, you exempted a facility if it is a 9-bed facility at, using a unit of the Vermont Psychiatric Care Hospital, repurposing it, that would be exempted from a CON review, and that was Act 27 last year.
We did that in Act 27. Yeah.
I'm 95% sure.
It wasn't
Let me look
78.
down
I'm trying to
the
remember where it was.
I
Yeah.
think it was in 27. Let me stop sharing and I'll take a look.
So I was going to say we'd take a break for 5 minutes and then do a scroll through of the bill itself before we finish. So can we do that? Take a 5 minute and then come back.